Can a state forbid the teaching of critical race theory? Do students' First Amendment rights to receive information place limits on state curricular decisions? Jamie, you ready for some 1984 George Orwell references? Because I think the decision we're talking about today is doubly plus ungood.
Oh, well, it's a bright, cold day in November, and the clocks are striking 13. Again. This is another timely and relevant case for you. Today, we're going to be talking about the constitutionality of an Arkansas law that was designed to regulate how we teach and talk about sensitive subjects like race and gender. As we all know, these kinds of laws have popped up all over the place over the last few years, and in many cases, they've had some pretty chilling effects on what happens in classrooms. Whether the laws allow you to engage certain topics or ideas, the dialogue around all of this stuff is loud, it's often confusing, and it's pretty emotionally charged, right? So that leads a lot of folks to self-censor, okay? Even when they might not have to.
Right.
Yeah. So we're going to unpack Walz versus Sanders on today's episode. Welcome to Chalk and Gavel, everybody, where we explore how the law shapes education, one case at a time. I'm Jamie Cudlitz. I'm a former middle school math teacher and principal.
And I'm Chris Thomas. I've been a high school English teacher and a school attorney. Now we're both professors of educational leadership, bringing you the fascinating stories connecting the courtroom to the classroom.
Gavel is for educational purposes only. While Chris and Jamie always try to provide accurate information, the law is like what I'm willing to eat. It's always changing. This podcast is not legal advice and does not create an attorney-client relationship, but they promised me it would be a lot of fun. For you. Can I get my candy now?
Okay, welcome back, everybody. Thank you for listening. Don't forget to rate and review Chalk and Gavel. If you're checking us out on YouTube, please give the video a thumbs up and subscribe to our channel. We also have a new website. We redesigned our website. It's quite nice. It's a lot nicer than the old one.
Jamie says we, but it's really Jamie redesigned our website.
Well, it's okay. This is not my full-time gig, web design. So go to chalkandgavel.com. You can sign up for our newsletter, which we hope to start sending out very soon. You can find out more information about the show. What else?
What else can they find on the website, Jamie?
Oh, there's two other really cool things that you can find on the website. The first thing, we've got a great place for you to support the show and many options for you to support the show because, like we've said before, this is a labor of love. This is not our full-time gig. We do this because we love it. And so to help us cover costs, we rely on the generosity of our listeners. So there's a great place on our website. It says support the show. There's a link in the show notes. You can go there. You can make a one-time contribution. You can make recurring contributions, any amount you'd like. That would go a long way to help us sustain the show. And then the second thing, which is also really cool, is Chalk and Gavel now has merch.
We've got merch.
There's t-shirts and sweatshirts and mugs and notebooks. There's a notebook on the cover that says document.
Just in case you forget.
Yeah. So
there's a mouse pad that says don't do nothing.
Yes, because everybody still uses mouse pads, right? Is that a thing? I just remember 20, 25 years ago, the novelty mouse pads were all the rage.
I mean, nothing about this show is outdated, especially not my new mustache. So,
well, I am outdated. So I'm here with Magnum PI today.
Well, this is the natural progression from the mutton chops of a couple episodes ago or whenever that was.
Yeah, and I just realized I said Magnum PI, and half of our listeners probably went, I don't know what you're talking about.
Well, I think most of them probably know that one.
Yeah, the Tom Selleck version, though?
I'm sure. Like,
okay,
yeah.
It's enough of a cultural...
It's in the zeitgeist. It's
yeah.
in the zeitgeist.
Okay.
Yeah.
Yeah. So check out chalkandgavel.com. It's a nice new website there. We're going to keep adding stuff to it and buy some merch because it's fun to have that nice little Chalk and Gavel logo on various items. There's a dad hat to go with your cargo shorts. And
we should get some branded New Balance.
All right, let's get into this thing today. What's our bell ringer, Chris?
Sure. So for our bell ringer today, I want to talk about some disruption at the U.S. Department of Education. Not something we've talked about before. This is a different iteration, I guess, of that. Okay. So we're recording this at the beginning of November. So we're still in the midst of the federal government shutdown that began in October. But during that shutdown, the Trump administration announced that it was laying off 121 employees in the Office of Special Education and Rehabilitative Services.
Given everything that has happened since January, I was surprised that there were 121 employees left there.
I know that this office hasn't been touched as heavily, but this round of layoffs
till now.
Exactly. It included nearly every single person or every single employee in the Office for Special Education Programs. So this is OSEP, which is the office that administers funding and oversight for implementing the Individuals with Disabilities Education Act, the IDEA. So this is like the federal office to implement IDEA. And by firing 121 employees, that pretty much means that there's only a handful of senior staff left at the office. Everyone else is gone. And so special education advocates were really concerned about these layoffs because of everything OSEP does. They're responsible for providing grants for special education funding, monitoring state implementation of the IDEA, providing other supports and like guidance to ensure the IDEA is appropriately implemented. Like this office does a ton of stuff for students with disabilities, and now those people are gone. Yeah. Except following the layoffs, there was a lawsuit because that's the life cycle of these sorts of things these days. Right. Yes. And so there was a lawsuit challenging the layoffs, saying that basically they were improper, they weren't done the right way. And, you know, part of the argument is that they essentially prevent offices like OSEP from fulfilling their statutory obligations. And that's an important piece of all of this that I think is important to remember is like, just because the people aren't there, the law doesn't change. Exactly. Yes. So like IDEA is still the law, the same requirements there. There's still the same funding, and that funding's got to go somewhere. It's got to get to the people, the states and the local education organizations somehow, right? So none of that has changed. So there's this lawsuit challenging this. The plaintiffs, the employees and their unions ask for an injunction, basically saying, stop, you can't do this right now because we'll suffer irreparable harm and we're going to win our lawsuit eventually. And the court, in this case, granted the injunction. So the judge, and this was for a bunch of reductions in force, not just OSEP, but the judge indefinitely blocked the Trump administration from implementing the reductions in force issued during the governmental shutdown, and also ordered them not to issue new ones. So, hey, stop doing that and don't start again because I told you to stop. So OSEP still has staff for now. I'm not sure how many of them are currently working because of the government shutdown and all of that, but they at least still have their jobs. But another interesting thing about all of this is while this is all going on, while they've pretty much eliminated OSEP, the Office for Special Education Programs, a U.S. DOE spokesperson confirmed that the Department of Education is, quote, exploring additional partnerships, end quote, to support special education programs. So in the past, President Trump and Secretary of Education McMahon have talked about wanting to move special education to another department. They often talk about the Department of Health and Human Services as part of their goal to kind of eliminate the Department of Education. And so firing OSEP and all of the staff may have been kind of the first step towards shifting its responsibilities to implement IDEA to another department, which again could have really serious implications. You know, in the short term, definitely because there's so much institutional knowledge and there's a lot of concerns from folks about kind of continuity of special education funding and supports from the federal level. So like there's a lot of disruption happening right now with special education from the federal government.
And just, you know, just individual expertise. right?
Right.
Institutional knowledge, institutional history, all of that stuff going away is one thing, and it's a big thing, but all of a sudden tasking people with carrying out some of the statutory requirements of this who have no idea about the IDEA.
They'll have to rebuild the plane.
Yeah, exactly.
Yeah.
So,
and it's a pretty complicated plane.
Well, yeah. I mean, this has been around in some form or another for 50 plus years.
Since the 70s.
That's a depressing bell ringer. Thanks, Chris.
Well, if you liked that, just wait for this case.
But wait, there's more. We should have put that on the merch. But wait, there's more. That would have been good. Well, let's
you know what?
something.
That'd be great to put on the webpage.
All right. Well, let's get into today's case.
I'll talk to our merch designer.
Yeah, you are the merch designer.
I know.
It's that Princess Bride quote. We call the Brute Squad. You are the Brute Squad.
I love that. That's one of my top 5 favorite movies.
Oh, it's classic. Okay, today let's see if we can work in a Princess Bride reference. Another one to today's episode.
I would prefer it to the 1984 references.
Yeah, well, anything. All right. So we've talked a lot about the wave of state laws that began in like 2022-ish that seek to regulate how schools talk about race, racism, sex, sexism. You know, this has been an ongoing conversation on Chalk and Gavel and in many other places. So, we're going to talk about one of those situations today. So sometimes you hear these laws that we talk about, sometimes you hear them called anti-CRT laws, parental rights laws, things like that. We've called them curricular bans. We've called them curricular gag orders, those kinds of things. It's the laws that really, try to get at regulating what schools can do, what they can teach, what teachers can talk about, all of that stuff, big topics over the last 3 years or so. But the interesting thing is I don't think we've done an entire episode on one of the lawsuits that actually asks whether or not one of these laws is constitutional, is legal.
Right. I think it's been mostly bell ringers.
Yeah. So here we go. It's an episode on one of these laws. So first, really quickly, this is a law that is kind of described as sort of one of those anti-CRT laws. So what is CRT? Critical race theory. Okay. So there's a lot to it, but we'll just make it really simple first. Essentially, it's an academic theory that looks at how laws, policies, or systems can sometimes create or perpetuate racial inequality, often without any intention to do so. So this isn't about necessarily individualistic racism or anything like that. It's more about these big systems or big policies or big laws that have an effect, right, on promoting or, some sort of racial hierarchy.
Right. Yeah. And it got its start in colleges of law, right?
Yeah.
So this is a graduate level theory.
And I think that's where most of this conversation around CRT exists. It is a college, not just college, but graduate level. Personally, I remember learning about it for the first time when I was studying for my PhD. This was, 15 years ago or so. I had honestly never heard it before in all my years as an educator, had never even heard the term until I became a PhD student. So most of the, CRT conversations don't necessarily come up in K-12. This is largely focused in higher ed.
Right. Yeah. But that concept of CRT kind of got co-opted and in many ways kind of turned into a straw man for conversations about race and inequality in kind of, public policy discourse. Right. So a lot of people talk about CRT, but they're not necessarily talking about the thing we're talking about.
Yes.
Exactly. Right. They keep using that word. I don't think it means what you think it means.
There it is.
There it is.
There it is. Well
Princess Bride
done. Nice. Beautifully and natural too. It was like a perfect fit.
I'm pretty proud of that.
Wow, that was unplanned, folks. Like we script some of these terrible jokes. That one was not.
I think we script all the terrible jokes. It's the good ones we don't.
It's the good ones we don't. Okay, so today's case focuses on the LEARNS Act, Learns. Okay, the LEARNS Act. It was enacted by Arkansas in March of 2023. Okay, now one of the provisions of this act, called Section 16, directed...
Which already sounds ominous.
It does. It does.
We're going to talk about Section 16 today.
That, yeah, it's very dark. So Section 16 directed the Arkansas Department of Education to comply with Titles 4 and 6 of the 1964 Civil Rights Act. Okay?
Great.
So basically, with respect to reviewing its communications and materials to see if they, quote, promote teaching that would indoctrinate students with ideologies such as critical race theory, otherwise known as CRT.
Okay. So basically they're looking at the Civil Rights Act and saying, like, we think these things violate that. So please follow that, but follow our version of it, which we've kind of seen a lot reinterpretation of Title VI, in these ways. Okay.
So they're relying on the Civil Rights Act, which is like, hey, this is an act designed to eliminate discrimination, racial discrimination, right?
Yeah.
And they're using that and then sort of further defining what that act covers.
Right.
Is that a good way to kind of
I think so, yeah. So basically they're saying, like, CRT is a discriminatory ideology and Title VI prohibits discrimination.
Right.
So therefore it also prohibits CRT.
Right.
Right.
So the law also required the department to eliminate any, quote, prohibited indoctrination, unquote.
As opposed to allowed indoctrination.
Yeah.
Sorry.
I think
it's
some
the
people
adjective
that I think some people would look at what's happening in some schools, in some states, as this kind of indoctrination is perfectly fine. That kind of indoctrination is not perfectly fine. My kind is fine. Your kind is not.
And that's the greatest irony of a lot of these laws is they are called anti-indoctrination. So, like, I think Section 16 in the law is called, like, the anti-indoctrination principle or provision or whatever. But, like, in order to fight indoctrination, you
have
basically, it's, I guess, like, what's the word? Doublespeak. 1984 reference, right? Like, it just feels like, hey, we're going to fight indoctrination by indoctrinating.
Yes.
Right? So, like, we're going to tell you what to think in order to prevent you from being told what to think. Right? Like,
yeah. So that's what this law was designed to do. Basically, you need to look at your rules, your policies, your materials, your communications, and look for elements of indoctrination. You need to, eliminate things that promote ideologies like critical race theory. That's what the law was for. So how do they define prohibited indoctrination under this law? Like, that's going to be the critical question here. Like, okay, you don't want us to indoctrinate students? What do you mean by that? What falls into your category of indoctrination?
Right. And this is where a lot of these laws fall flat because it's really hard to define stuff like this.
Right.
In a clear way.
Yes.
Right?
Yes.
How does it define prohibited indoctrination?
Because usually the response to that is like, well, indoctrination.
I know it when I see it.
So here's how this law defined prohibited discrimination. Well, I don't know.
Easy for us to say.
I don't know why that one's a hard one for me to say. So it defined prohibited discrimination, got it, as communication that compels a person to adopt, affirm, or profess an idea in violation of Title IV and Title VI of the Civil Rights Act of 1964. Okay?
So adopt, affirm, profess, right? That's the
coercion.
The coercion side of the spectrum, right?
Yeah. the interesting thing is in so many of these situations, they say coercion is bad, indoctrination is bad. We agree, right? But I think what happens in a lot of these situations is they often equate talking about something to being coerced into believing it. And that's where a lot of the disconnect.
Which is what we saw in Mahmoud, right?
Exactly. In with those books.
Mahmoud, the LGBTQ classroom books case, it was the exposure to it that was infringing the parents' right to direct the care and upbringing, religious care and upbringing of their children.
Yeah. So it wasn't coercion, but they were basically saying exposing is enough coercion in that case.
Right.
But like we've said many times on the show, and I say it a lot in the classes that I teach, the courts have repeatedly said over the years, less so recently, but that mere exposure to ideas, it's an offshoot of the idea that it is baked into the First Amendment, that you might not agree with what I have to say, but I'm allowed to say it for the most part. And that idea behind, we're not forcing you what to believe just when we tell you something that you don't agree with. Right.
Yeah. One of the justifications for the First Amendment is that it protects this robust marketplace of ideas where all these different viewpoints, or basically everything worth saying, needs to be said. Yeah. Is kind of the justification here. Right. And so this idea that just being exposed to something is, violative of the law, seems to run afoul of those kind of First Amendment ideas.
Yeah. So basically, this law, this Arkansas law that says that it is prohibited to compel a person to adopt, affirm, or profess an idea in violation of the Civil Rights Act includes things like people of one color, creed, race, ethnicity, sex, age, marital status, familial status, all the things
that you're list of protected characteristics, right?
Those protected characteristics, all of those things, you cannot basically say that any of those things are inherently superior or inferior.
Okay. Yeah.
Okay.
That sounds great.
I'm on board. It also says an individual should be discriminated against.
This is what you can't teach.
Yeah, this is
what you can't force someone to believe.
Right. An individual should be discriminated against or receive adverse treatment solely or partly because of the individual's color, creed, race, blah, 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 all those things. Okay.
Okay. So basically,
you can't discriminate.
Right. And you can't treat someone differently because of a protected class.
Yeah.
So those two things.
That's just the Civil Rights Act, right?
They don't do anything new. Exactly. Yeah. So it's that kind of linguistic trickeration, I don't know, that they do where they kind of say here's what the Title VI says. And I interpret that to include this much bigger thing that isn't doing these things, but I think it's close enough.
I say it is. Yeah.
I say it is, right? And that's kind of what's happening here. And that's kind of the chilling effect here, because if those definitions are broad enough to encompass these other ideas, what else are they broad enough to encompass? Is kind of the question, right?
You want me to blow your mind?
Always.
Okay. Because there are exceptions to the law, and the exceptions to the law are pretty much just what you said.
Okay.
That it doesn't prohibit discussions about, quote, ideas and the history of concepts described in the definition of prohibited discrimination.
So we can teach the history of discrimination?
We can teach, that's what it sounds like to me. We can teach the history of discrimination. We can talk about ideas.
I can teach about the ideas?
Yeah. Okay. And it also doesn't prohibit discussions of, quote, public policy issues that individuals may find unwelcome, disagreeable, or offensive, unquote. Okay. So we're basically, to me, it sounds like the law has provided exceptions to talk about difficult topics that not everybody is necessarily going to agree with, okay? And to examine ideas and historical backgrounds of discrimination, essentially.
So, sure, but then, like, what does the law cover that isn't addressed by the exception? Right? It feels like the exception is swallowing the rule.
I think that's what they want it to do.
So then what does the rule do?
Provides a framework for the exception to be, I don't know if that makes sense. It does in my head, but I think hopefully this illustrates one of the points we're trying to make
which is that these laws are not self-defining, right?
Yeah. They're not good laws. And I am not making a claim one way or the other.
That's not a normative claim. That's
right. It is a poorly written law. Period.
Or, the problem with ambiguity is it leads people to be safe, right? And so a poorly written law, may have a more pronounced chilling effect than a well-written law.
Yeah, and we're not saying that, being safe is a good thing. Okay? I'm not, there's playing it safe and there's playing it too safe. And I think, Chris's point is that these kinds of ambiguous laws force people to way overcorrect, way overcompensate,
right, exactly.
Because they don't know where the line is between safe and unsafe.
Right.
Because the law does not define where that line is.
Right. Okay? Which has led a number of people to bring lawsuits against laws like this, including here against the LEARNS Act.
And that's what happened. So
and that's what happened.
Tell us about the lawsuit, Chris.
Yeah. So a group of students, teachers, and the Arkansas state chapter of the NAACP, they bring this lawsuit against the LEARNS Act in federal court, and they're arguing that it's unconstitutional because it's overly vague, like we just talked about, which violates the 14th Amendment's due process clause, and it violates the First Amendment because of its chilling effect on teachers and because it violates students' right to receive information. So those are the plaintiff's arguments here. So while it's not necessarily a big part of the decision we're talking about today, the void for vagueness doctrine, which is one of their arguments, under the 14th Amendment requires that all laws be sufficiently clear so that an ordinary person could understand what is allowed and what isn't, right? Sounds, probably something we want from our laws. Basically, if a law is too unclear or if it gives the people enforcing it too much discretion to decide whether something does or doesn't violate the law, that's fundamentally unfair. That violates due process. Okay. So a number of lawsuits challenging anti-CRT laws like this, they've made the same argument that these laws are void for vagueness. And a number of those have been successful on those grounds, basically saying these laws are too unclear. It's too unclear what they mean, what they apply to, what the exception means, whether the exception applies or not. All of that to say an ordinary person wouldn't know how to align their conduct with these laws. Therefore, they violate the 14th Amendment's due process clause.
Okay.
However, that's not the case here. And it's not the case here because of some really interesting legal strategy things that happen in this case. So the plaintiffs ask for a preliminary injunction. They want to pause enforcement of the law. That happens in a lot of lawsuits like this. To get their PI, you have to show a likelihood of success on the merits, and you have to show that you'd be irreparably harmed without the pause. And so we've got a number of different plaintiffs here. We've got students, teachers, the NAACP, and they make different arguments. So the teachers argue that Section 16 is void for vagueness. It's too vague to give them reasonable, to communicate what is or is not allowed.
Right.
The students, on the other hand, are arguing that this violates the First Amendment, violates their right to receive information because it removes some ideas from the curriculum while allowing others.
Okay.
And in addressing these arguments, the trial said no to the teachers, but yes to the students.
Said no to the teachers.
No to the teachers because the trial court concluded that the speech at issue was the government's speech. So any potential chilling effect or harm was not violating the teacher's rights because teachers don't, in the K-12 context, have
those rights.
Don't have rights to direct the curriculum. We talked about that with our Boring versus Buncombe County case, right? Different though for the students. The trial court did issue an injunction based on the students' First Amendment claim.
They're not basically saying that the idea that this law is unconstitutionally vague, they're not answering that question. They're just saying, teachers, you're the wrong people to be asking that question because you don't have a right.
Right. Yeah. You don't have a right that's implicated here. So even if there is a harm, it's not a harm to a protected right.
Got it.
Yeah.
Okay. Yeah.
Yeah. And yeah, for the students though, that wasn't the issue, right?
Yeah.
Because the court concluded that like a reasonable person could look at Section 16 and, make the assumption that it prohibits teaching about CRT, and therefore, it removes that from the curriculum.
Yeah.
And that has a chilling effect, which prevents students from receiving that information. So, that violates their First Amendment right to receive information. And one interesting thing here is I'm pretty sure the state of Arkansas was arguing that the law didn't prohibit the teaching of CRT, which is, again, another wonderful example of doublespeak.
Well, yeah, because the exceptions in the law basically say you could do it.
But then you look at all the popular reporting about the law and
but there's
even
other
the name
language
of the law.
Yeah, and there's language in the law that basically says some of the ideas that we think CRT is about.
Right.
Those are prohibited.
Right.
But
So there was some interesting legal machinations in this whole thing from both sides, really.
Yeah.
So the lower court issues an injunction telling Arkansas to stop this law because of students' right to receive information. Arkansas didn't necessarily like that because they appealed to the 8th Circuit Court of Appeals. So we're in front of a 3-judge panel of the 8th Circuit. That's typically how these things go. And the panel has to decide whether or not the trial court got it right to give the students a preliminary injunction. Surprisingly, or maybe not surprisingly, given how things go at the 8th Circuit, the teachers chose not to appeal the court's opinion denying them a preliminary injunction. So it's just the students' argument the court is looking at. So void for vagueness is off the table right now.
Yeah. Okay.
And I did some digging about who the judges were on this panel. And they were all appointed by different Republican presidents, which actually is kind of interesting. So one was appointed by George H.W. Bush, another was appointed by President George W. Bush, and the third was appointed by President Trump.
Okay.
So all Republican appointees, though spanning decades, right?
Yeah.
So the court starts by looking at the student's right to receive information claim, because this is the only claim kind of on the table right now.
Yep.
And things start off looking pretty okay for the students. The court says that the free speech clause protects a speaker's ability to share information, and that this includes a reciprocal right to receive information.
Okay.
Essentially, a law that requires everyone in the audience to wear earplugs would have pretty much the same effect as prohibiting the speaker from speaking. So essentially, we don't want the government to be able to skirt the First Amendment by prohibiting a willing listener from listening to the message of a speaker.
Okay.
So, it's kind of a two sides of the same coin sort of thing.
Yep.
And the court goes on to say that such principles do not disappear inside the public school because, quoting Tinker, students and teachers don't shed their constitutional rights to freedom of speech or expression at the schoolhouse gate.
Okay.
All good so far.
Then what?
It's all downhill from there from the students, because the very next thing the court says is that, quote, the students sensibly concede the classroom materials and instruction they want to receive constitute the government's own speech. And that's a big deal because of this thing called the government speech doctrine.
Okay, Chris, get into it.
So the government speech doctrine is basically just the idea that when the government speaks, it should be allowed to choose its message. Essentially, the Supreme Court has said that the First Amendment free speech protections don't restrict governmental speech. When the government speaks, the government speaks on tons of things, right? And when it's the one speaking, we want it to be able to promote the views that the people in charge want to promote. So, just think of the Don't Do Drugs campaign, right? That's a view, right? The view is drugs are bad, don't do them. So, if the First Amendment applied, then, now we've got these really tricky questions about, can the government engage in viewpoint discrimination, content discrimination? The government's always going to be speaking from a particular perspective.
Sure.
Right? And so that's kind of why the government speech doctrine has kind of evolved. It's come up in the curricular context before. A lot of courts have been really hesitant to say that curriculum is governmental speech free from First Amendment restrictions just because of, all of the rights and other things wrapped up in school curriculum. So, there's a slippery slope here, I think. And I don't think the arguments for exempting curriculum decisions from the First Amendment hold up very well. There's so many. I'm going to get my soapbox out. I'm sorry. I'm sorry in advance.
It's all right. It's like perpetually set up. It's always, it's always there.
Well, this is one of those things that like I feel really passionate about because I tend to focus on the students, right? You and I have talked about that before. Where like it's the students' rights here, and by basically saying that the curriculum is government speech, the court is saying that students' rights to receive information are inapplicable. Essentially, that like there are no rights that students have to tell the government what to do or how to do anything related to the curriculum, because that's government speech over which they have complete authority.
It's a very interesting thing, especially in light of, other cases we've talked about on the show, like Evans versus Hawes, which was that case about the student who had to read a monologue in the drama class, and it was a pretty, explicit monologue. Yeah, like that. It's like this idea has some very interesting implications depending on what side of the equation you're on.
Right. It essentially gives the government license to
say whatever they want and don't say whatever they want.
Right. Yeah. So in many ways, it is a license to maybe not coerce belief, but like to indoctrinate,
to pick and choose the information that they feel they want to they want to share.
Right. Yeah. So like, the quote from 1984 that always kind of pops out to me at this point is like, he who controls the present controls the past. He who controls the past controls the future. Right. So like, it's this idea where like, if you can tell the story in a certain way, you can shape the future of that story. Right. And, there's a lot of reasons why, not only just like that kind of practical, like if you take this too far, then obviously there might be some problems. But, there's a lot of other arguments why I think that calling the curriculum government speech doesn't really work. The first is that students are forced to go to school, right? Like they are compelled to attend schools. They're not compelled to attend public schools. They can go to private schools and things like that. But like having a captive audience was one of the big things in Bethel. It was a big concern of Justice Alito in Mahmoud, and captive audiences deserve some sort of heightened protection. So like, sure, it's the government speech, but like you're forcing kids to listen to it. So like maybe that's a reason why we shouldn't just give the government carte blanche about what it is they say.
Right.
Another thing, students are kids. They're impressionable. That was another big concern of Mahmoud. So, it's incredibly ironic to allow for this kind of indoctrination that we just talked about when you're adjudicating a law that's called the anti-indoctrination provision. So like, there's a very real sense of irony here. The third is like Evans versus Hawes raises this really well. Curriculum is kind of wrapped up in student speech in so many ways, right? Like, the argument in Evans versus Hawes was that this student giving this presentation was her speech, right? Even though it was a class assignment, it's part of the curriculum. So like there's this deep entanglement between student speech and government speech here, if we call it government speech. And so, it's not really fair to call the curriculum purely governmental speech because of this intertwinement. And I also have a question of like, fundamentally, is the curriculum speech at all? Because like, while teachers teaching the curriculum is speech, and I don't question that, like the curriculum is way more than just the act of teaching, right? Like a lot of this stuff is conduct. It's not necessarily speech. So like calling it all speech seems to wrap way too broadly. I think like if we call this speech, then like what does the government do that isn't speech? I think is actually a really interesting question. Because like then what else does this remove from potential constitutional protections? There's also these questions about like children's development, right? So they're young, they're impressionable, and they have like, we protect their current liberty in order to protect like kind of the future autonomous adults they're going to be becoming. So that means we probably shouldn't allow people to kind of put their finger on the scale early in their lives. And then the last one is just kind of this democracy argument, which is like the marketplace of ideas, right? Like we want people to engage in the marketplace of ideas. We can't do that if we remove certain ideas from the marketplace of ideas. Or if the government is allowed to remove those things, and schools are such an important mechanisms for kind of helping students develop their citizenship.
Yeah.
If you don't have those ideas in schools, then where are students going to be exposed to them?
Right.
And so like all of those are the reasons like I'm deeply, deeply concerned by the argument here and just the like kind of flippant conclusion that this is government speech that is removed from these other First Amendment protections.
Yeah, that is a scary perspective. And yeah, like it's interesting. We've called it everything you can possibly call it on this show. The irony, doublespeak. Like if your head is spinning because you're like, wait, like it sounds like they want to have their cake and eat it too. And it feels like that's a lot of, and it goes back to what we said at the beginning, right? About how if it's your idea, it's indoctrination. If it's my idea, it's not indoctrination. Right?
Yeah. And that goes back to something my First Amendment professor told me, or told the class. Like, if the First Amendment only protects the speech you like, it's not doing much. Yeah. And I think the inverse of that is true as well. Like, I don't think this is a partisan argument, right? Like, I think that like everyone can have some like deep concerns about how the implications for this decision can be leveraged by the left or right.
Totally.
To really kind of like reshape what we think of when we think of public education.
Right.
So interestingly, building off of our conversation, the court does acknowledge the problematic potential of its ruling. So the court, to their credit, right? Okay. So at the end of the First Amendment section, they say, quote, "We do not minimize the student's concern, whether in this case or in the abstract, about a government that decides to exercise its discretion over the public school curriculum by prioritizing ideological interests over educational ones." End quote. So the court's like aware that what it's doing, right?
What it's doing, and it's just acknowledging what it's doing.
Right. Yeah. And the court kind of waves that away and says like, yeah, we don't minimize that. Like, hey, that's a real concern. We get it.
It's just not a concern to us right now.
Right. That's kind of exactly what they said. That they said that this is something
it's your concern. We acknowledge
it's for
that
the policy processes, right? Like it's for the elected branches of governments because they're the ones that are in charge of that over education, right? So this is a question for if you don't like what the government is telling you to teach, then like, hey, vote that government out and get a new one. Right? That's kind of what they're saying. They're basically saying like, the check on all of this is the democratic process.
Yeah.
Right. My response to that, well, I have a number of responses to that. The first is, hey, that's not what the First Amendment does. The First Amendment protects things from the political process. So looking to the political process to protect your First Amendment rights is backwards.
Exactly.
And, two other things that it kind of really ignores is like, one is that schools themselves are one of the primary means by which we prepare students for democratic citizenship. Mm-hmm. So if we're looking to the political process to fix the imbalanced school curriculum, let's call it that, then we're asking the political process to fix something that distorts the political process, right? Because essentially like schools teach students to engage in the process.
Yeah.
The process itself is the thing you're asking to fix the thing that the students are learning. So like it's this weird cycle where like, how's it going to fix itself if the mechanism by which it's supposed to be fixed is broken?
Yeah.
Right?
Yeah.
So, that's a big issue. And the other massive issue I have with this opinion and that argument is like the court completely ignores West Virginia versus Barnett.
Oh, right.
Right? Which is the 1943 flag salute case.
Yeah.
And I think
Chris's favorite, by the way.
The amount of times we talk about it on this show, I think like it might be I think it's ascended to that top spot.
Oh yeah.
Right.
Yeah.
Because I think I've quoted this exact line, mostly from memory at this point, a number of times. But the Supreme Court in Barnett said, if there's any fixed star in our constitutional constellation, it's that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess by word or act their faith therein. And I think that's pretty unambiguous.
It's unambiguous. And I think the first part of that is what the court in this case said it was perfectly fine to just do. Right?
As long as the political process can fix it,
Yeah.
Right?
Like, you don't like what the government has to say, then find a new government.
Right.
Whereas West Virginia versus Barnett said the government can't tell you what is orthodox.
Right. It can't tell you what to believe. There's a
No.
freedom of consciousness that we have as individuals that is, that needs to be protected from governmental interference.
Right. Right. And
Right.
so, West Virginia versus Barnett essentially implied that there is almost a governmental responsibility to, maybe I'm reading a little too much into it. Maybe I'm but it almost, to me, it almost implies that you can't prescribe what shall be orthodox, which kind of implies to me that you have an obligation, you have a responsibility to basically put it all out there.
To provide a range of options, or to not unnecessarily constrain the options, right?
Right.
Yeah.
Exactly.
And I completely agree with you. Like, that's the direction I would take this all. And that's kind of one of the arguments that the court rejects that the students were making. So the students were kind of arguing that, like, hey, taking this out, like, impermissibly because it was motivated by partisan or ideological reasons, like, that's a big problem under PICO, which we've talked about recently as well. And the Eighth Circuit here kind of says, like, well, that's weird because that's only a one-way thing. Like, it's only a problem when you take something out of the curriculum. And that's kind of what PICO said, but like West Virginia v. Barnett, it's not worried about taking stuff out. It's not worried about putting stuff in. It's worried about, like, what is actually being taught.
Yeah.
Right. And if what's being taught is
a particular orthodoxy.
Right.
Coming
if it's
from the
coercing
government.
belief or, violating that freedom of conscience, then it's a problem.
Yep.
And so a government policy that, like, takes ideas off the table for ideological reasons, like, that seems to be problematic, but so too would be a curriculum that only has one ideology.
Exactly.
That would also be equally problematic under Barnett. So
No, oh man. Listen, if your head is spinning at this point, I wouldn't blame you, because not only is this stuff,
heavy, complicated.
It's heavy and complicated, right? It's very heavy. It's very complicated. And there is a lot of distortion. I guess is probably the best way to put it. There's a lot of distortion in this area right now, which is naturally heavy and complicated to begin with. When you add all of this distortion, all of this fury of activity, all right, from a law and policy perspective, when you add all of that to, and the double speak and the, like, you are distorting an already complex and weighty, very weighty issue.
Right.
Okay. With massive implications for freedom and democracy, to, not to make that sound overly, I don't know what the word is.
Right. We're not like trying to be grandiose, right?
No, but like that's where we're at here. And so, given all of that, what the hell do we do about it? Like, okay, you're a teacher, you're an administrator listening to this podcast, and you're like, okay, that's all well and good, but I got to go to school tomorrow. Right.
Right.
And what does this mean? And, and I basically, like, the first thing I'll say, and I think we've said it before on the show, is like, I don't blame you if you want to be overly cautious around these kinds of issues right now. We have seen more times than we can count the very real practical implications that affect people's lives when they go against some of these policies or laws or whatever. So there is no judgment. There is no blaming. If you are concerned and you want to be overly cautious about this stuff, and it's hard to provide any other advice or takeaways in such a rapidly changing law and policy landscape.
Right.
That is so state specific at this point. But, I think one of the big important things is not only stay aware of your policies and engage with the political process and try to really understand what the laws are and how they're written, and the more legally literate you are, the more you are able to identify what is a good law and a bad law, what is an, ambiguous.
And the more empowered you are to navigate ambiguity.
Exactly.
Right? And to advocate for what you think is, in the best interest of the students.
Totally. But, at the end of the day with this stuff, and one of the places where the court in this particular case got it right is, if you don't like something, engage in the political process. I don't disagree with that idea, whether or not it's the right idea to govern this particular case is a different, I've got a different opinion about that. But the idea of making your voice heard and exercising your rights as a citizen to elect and all of that is very important. Yeah. So, takeaways, keep fighting the good fight and do what you can to ensure that your students are getting the best that you can give them. And
always.
Yeah, like and sometimes that is hard. And sometimes your school board, sometimes your state, sometimes whoever makes that job very, very difficult, but
right.
Being legally literate, like Chris said, can empower you to navigate that ambiguity more comfortably, more safely. Yeah.
Mm-hmm.
That's all I got.
I think that was really good.
Oh, thanks.
Very eloquently said.
Oh. No, I don't think it was eloquent, but it was pretty rambly. But hopefully you got the message.
Yeah. I think it was forceful.
It was. That was me on my soapbox. We all have soapboxes.
Yeah. I'll let you borrow it for a second.
Thank you. I appreciate that. So what's our homework, sir?
Your homework is to, I think, go watch Princess Bride, because that's what I want to do right now.
Buy a Chalk and Gavel t-shirt and sweatshirt.
Yeah.
It's comfy.
Oh,
sit on the couch.
We have some really comfy sweaters that look really, I'm very tempted.
Yes.
Yes. Maybe that's what we need. We need a Chalk and Gavel blanket. But yeah, so I'm going to go, watch about some rodents of extraordinary size and
ROUS.
Say inconceivable.
Stop that rhyming and I mean it. Did anybody want a peanut? Fezzik, are there rocks up ahead? If there are, we'll all be dead. Okay, that's enough.
There's so many good lines there.
Yeah. Rate and review. Check out our new website, chalkandgavel.com, all that stuff. And we'll see you again in 2 weeks, everybody. Have a good one.